Regina Campbell. I'm the managing attorney here at the Campbell Law Group, coming to you again from Coral Gables, Florida. Hope everyone's having a beautiful day. We want to go ahead and take this opportunity to wrap up a series that we've been doing. This is part 5 of the Tortious Interference series, and we're going to talk a little bit today about damages. As I've indicated in the prior segments, damages is one of the hardest elements to prove in addition to causation when we're referring to either kind of the tortious interferences, whether it's with an economic or advantageous business relationship or with a contractual relationship. And primarily because, once again, you have to have the connection between the acts and the actual damages. So the acts and the original elements of whether it's knowledge about a contract, intentional behavior to interfere with it, or an economic relationship. And then, of course, showing that these particular behaviors contributed specifically to the interference and actually caused the interference. Then you have to prove how much did it cost. So what kind of damages did that person cost you by behaving in this manner? Sometimes it's nominal. Sometimes we're talking about they may have just caused you a difficult time. You ultimately may not have lost the client, in which case you do not have damages and you will not have a case for tortious interference. There are circumstances in which the damages may be speculative. So in other words, if they're not an existing client with a past track history of how much you originally made with them, or for a certain amount of years, the likelihood that this person would have stayed with you and you would have made X amount of years based on past behavior, it becomes really hard to determine what your damages amounts are. In addition to that, you also have basically qualifying. You have to make sure there's no other market forces or other circumstances that potentially would have caused the interference, or cause the damages to be less, given certain circumstances, like for instance the contract rate might have gone down or the price of materials might have gone down. Also intervening factors such as your ability to actually do the job if you would have gotten it. So it's a very complicated area to figure out damages, but the most important thing is that you have to be able to tie the two together. The actual wrongful behavior with specifically this amount of damages that you've incurred, okay, or irreparable harm if it is to your reputation, or potentially to the community at large, which also may give rise to potentially to a defamation case as well. But most of the time you'll need experts to prove what your damages were in these type of cases. And if you're a startup company that doesn't have much past history, it becomes even harder to prove what your damages are. They become more speculative, and speculative damages are more often than not in law not permitted or not recoverable. So it also depends on the kind of records that you keep, so that you can prove the type of damages that you've incurred or what you might have gained from this particular client or contract or relationship. So as you should probably tell, it's very fact intense and important to, if you are going through something like this, you need to be very careful to tie the behavior to your actual damages to prove it. Otherwise it may not be, you may not have a case, or may not be a very strong case, in which case you want to consider litigation costs, whether it makes sense to get an expert, or maybe just talk to the other person, send them a cease and desist letter and say, listen, stop the shenanigans right now, or we're going to go into heavier territory, so to speak. Sometimes, more often than not, that is enough to get someone to stop. And if it's not, then you may have no choice but to move ahead, either with an injunction or potential claim for tortious interference, depending whether it's contractual or an economic relationship. So hopefully this has been helpful. If you need any more information or would like to run a case by us to see if you have, your case has the strength or merits and have the elements in order to meet tortious interference, do not hesitate to reach out to us. Thank you so much for everything. Thank you for tuning in. Bye-bye.